Across centuries, an empire without borders has refined a system to bind every person into a silent contract, one you never knowingly agreed to. This is the story of how the marriage between banking cartels and legal guilds replaced the people's common law with a jurisdiction called equity, and why that matters for every right you think you have. The Holy Roman Empire was crowned in the year 800, when Pope Leo III placed the crown on Charlemagne's head, a symbolic union of church and state. Over the centuries, papal bulls like Unam Sanctum, 1302, claimed all earthly authority under the spiritual head of Rome, asserting that every human soul and their property fell under papal trust. Banking soon became the empire's financial arm. By the 1600s, goldsmith bankers in Amsterdam, Genoa, and London perfected trust indentures, legal devices for holding property on behalf of another. While sold as protection, they were a mechanism of control. The trustee had the power, not the beneficiary. Parallel to this, the Inns of Court in London trained lawyers in Roman civil law traditions and ecclesiastical procedure, systems rooted in canon law, not the people's customs. By the late Middle Ages, this legal profession had formed a self-governing guild with exclusive control over courts and procedure. Here's the crucial shift. Common law is founded on the law of nature and nature's God as applied to society, protecting life, liberty, and property. It recognized absolute rights. Your property was yours, with none having superior claim. Equity, by contrast, was a royal creation. When common law courts refused cases on technical grounds, the king's chancery stepped in, ruling on conscience rather than fixed rights. Equity could compel or restrain a person, order performance of a contract, or decide what was fair, even if that meant ignoring common law. Over time, especially after the Judicature Acts of the late 1800s in England, equity absorbed common law. Instead of two systems balancing each other, one subsumed the other, and the judge's discretion replaced the jury's verdict. The decisive moment came in the 20th century. In 1913, the Federal Reserve Act privatized the U.S. money supply under a central banking cartel. In 1933, the Emergency Banking Act declared the United States bankrupt and pledged all property, public and private, as collateral for national debt. Birth certificates, once mere records, became security instruments, registered with the Department of Commerce and traded via the Depository Trust Company. Under this framework, your legal identity is treated as the trustee of an estate, the same estate pledged in 1933. Courts no longer operate under common law. They function under commercial equity, applying statutes and codes as contractual terms. Traffic tickets, property taxes, licensing, these are not matters of right and wrong, but conditions for use of property you no longer truly own. Judges act not as neutral arbiters, but as administrators of trusts and contracts, their loyalty sworn to the bar, under the Inns of Court founded in the Templar Church in London, the same order that financed medieval monarchs. In common law, silence is neutral. No contract can be forced upon you without your express consent. In equity, silence is consent. This flips the default. You are assumed to have agreed unless you explicitly rebut. The empire's genius was making this system invisible, so people don't even know they're bound. From 800 CE's coronation to 1933's financial coup, and now into the age of digital IDs and programmable currency, the strategy hasn't changed, only the tools. What was once parchment and wax seals is now blockchain and biometric databases. This isn't just history, it's the present operating system of the world. Knowing the rules is the first step to reclaiming your status under common law, where rights are absolute and not permissions granted by an administrator. The trust was built without your consent. The question now is, will you leave it unchallenged? Learn more by searching Burn the Corporate Fiction on YouTube, Rumble, and Facebook.